They told me I had no case. They said I had no chance. What happens when a quiet man refuses to believe either? My phone rang on a Thursday afternoon in February 2024. It was my lawyer, David Chen. He said the hearing had been reopened. I knew exactly what this was about. 7 years earlier, I was sitting in Courtroom 14 of Bridgewater County Courthouse. The room smelled like floor wax and old paper. The chairs were metal folding chairs arranged in 2 rows behind the bar. The fluorescent lights above me buzzed at a pitch that never changed. I had arrived at 8:47 a.m. with a manila folder and a pen. My son Caleb was 4 years old. He was home with my wife Nina. She had pressed my shirt the night before without me asking. The judge that morning was the Honorable Raymond Fairchild. He was 63 years old and had been on the family court bench for 19 years. He had the posture of a man who had stopped being surprised by anything. He picked up my petition with 2 fingers, like it was something damp. He read for 40 seconds. He set it down. "Mr. Osei," he said, "you're a warehouse logistics supervisor working rotating shifts. Day shift as of January," I said. He didn't write that down. The attorney across from me was Jonathan Fletcher, Esque, of Fletcher and Marks Family Law. He had a gold pen he kept clicking. He had a yellow legal pad he kept not writing on. He had the particular confidence of a man who had never lost in this courtroom. He smiled at the bench. "Your Honor," Fletcher said, "the petitioner has no established primary caregiver history. The child has been in his mother's home for the majority of his life. The mother has stable housing, a support network, a documented primary bond." Judge Fairchild nodded, like Fletcher was confirming something he already knew. "Mr. Osei," he said, "this court awards primary physical custody to mothers in cases of this type at a rate exceeding 88%. He didn't say it cruelly. That was the part that stayed with me. He said it the way a man announces rain. "Your petition for primary custody is denied. Interim visitation order stands. 2 weekends per month. We'll revisit in 18 months. He signed the order. He handed it to the clerk. He was already looking at the next file. Fletcher clicked his gold pen one more time and capped it. I watched him do it. I took the interim order from the clerk. I read it carefully, all 4 pages. I folded it once, cleanly, and slid it into the inside pocket of my coat. "Thank you," I said to no one in particular. I walked out. In the hallway, I passed a coffee pot on a folding table that no one trusted. I didn't stop. I walked to my car in the parking structure. I sat in the driver's seat without starting the engine. Behind me in courtroom 14, Fletcher was already on his phone, laughing at something unrelated. Judge Fairchild was already reading his next petition. Neither of them was thinking about me. I was thinking about both of them. I thought about Fletcher clicking his pen. I thought about the judge's exact words, "cases of this type." I had the interim order in my coat pocket. I had driven to 3 county courthouse visits in the past 4 months. Not for this case, but for background. I had been reading custody statutes since October. I had a yellow legal pad at home with 31 pages of notes. I thought about the phrase the judge used, "cases of this type." I started the car. I drove home. Caleb was in the living room when I walked in. He ran to me. He grabbed my leg and said, "Daddy." I picked him up. I held him for a long time. Nina came in from the kitchen. She looked at my face. She didn't ask. She knew I would tell her when there was something to tell. We ate dinner. I gave Caleb his bath. I read him 2 chapters of his book. I turned off his light. I came back to the kitchen table. Nina put a cup of coffee down next to me. She sat across from me. "What did the judge say?" she asked. "What I expected," I said. She nodded. She didn't leave. She stayed at the table with her own coffee while I opened my legal pad. I turned to page 31. I wrote the date at the top, February 4th, 2017. I wrote below it, "Interim order denied. Fletcher present. Fairchild presiding." Then I flipped back to page 19. There was a notation I had made 6 weeks ago from a state appellate ruling I had found in the courthouse archive room on a Saturday morning in December. I had marked it with a paper clip. I read it again. Then I read it a 3rd time. I put the legal pad down. I looked at the coffee cup. Nina was watching me. "You found something," she said. It wasn't a question. "Maybe," I said. She knew what maybe meant. I folded the interim custody order in half again and set it next to my legal pad. I would need both. I wasn't ready to move yet. But I knew something Judge Fairchild didn't, and I knew something Jonathan Fletcher, Esquire, with his gold pen and his yellow legal pad and his 88% win rate, hadn't thought to look for. I picked up my coffee. I was already 3 moves ahead. Before this story goes somewhere nobody expected, hit subscribe and stay until the end. What this man discovered next is the kind of thing lawyers don't talk about in open court. I went back to work the Monday after the hearing. The warehouse. Shift started at 6. I drove Caleb to daycare at 5:40. I picked him up at 4:30. I made dinner. I gave him his bath. I read his chapters. I turned off his light. Then I sat at the kitchen table and I read. This was February 2017. Caleb was 4 years and 4 months old. Nina watched me do this every night for 3 weeks before she said anything. "You're not sleeping," she said. "I'm sleeping enough," I said. She made coffee and sat across from me and didn't push. That was Nina. She believed in letting a person work. I had started with the State Domestic Relations Code, Title 14, all of it. I had printed 340 pages at the library on a Thursday evening for 10 cents per page. I kept them in a red accordion folder I bought at the office supply store on 5th Street for $4.89. The folder sat on the right side of the kitchen table. My legal pad sat on the left. The notation on page 19 was this: C, Mercer County, case number 1998-FC-0441, reversed on appeal. Footnote 7, section 14-0. I had found that footnote in November, while searching a different case entirely. I had written it down because it mentioned a statute section I hadn't seen cited in any current filing. The footnote referenced section 9.14 of the Domestic Relations Code. I hadn't been able to find the full text of 9.14 in the printed version I had. That told me something. On a Saturday morning in March 2017, I drove to the Bridgewater County Courthouse at 8 a.m. The records room opened at 8:15. I was the only person waiting. The clerk was a woman named Patrice who wore reading glasses on a chain and never asked why I was there. I told her I was looking for case records from the 1990s, Family Court Division. She pointed me to the basement. The basement of Bridgewater County Courthouse had shelves from floor to ceiling. Cardboard boxes with paper labels. Some of the labels had faded to unreadable. The fluorescent lights down there made a different kind of buzz than the ones in courtroom 14. Slower. There was a smell of old paper and moisture, and something that might have been printer toner from 30 years ago. I found the 1998 boxes on the 3rd row from the back. I pulled 3 boxes before I found the FC series. I found case number 1998-FC-0441 at 10:23 a.m. It was a thin file. The original ruling was 12 pages. The appeal was 23. I sat on the concrete floor with both documents in my lap. I read them slowly. I read footnote 7 in the appeal. Then I found the full text it was referencing. Section 9.14/ of the State Domestic Relations Code, as it read in 1998 and had never been amended since. When a custodial parent has relocated the minor child more than 40 miles from the established school district without prior court notification, and when such relocation has occurred more than once within a 36-month period, the court shall presume a material change in circumstances sufficient to warrant a full custody review. I read it twice. Then I sat there for a while. My phone said it was 10:41 a.m. The fluorescent light above me buzzed. I thought about something I had written in my legal pad on page 6, back in November, when I was just starting. I had noted that Caleb's mother had moved once to her sister's place in Fairfield in 2015, and once to a rental property in Bridgeport in 2016. I had noted both dates. I had noted both distances, because I drove them myself and checked the odometer. Fairfield, 43 miles. Bridgeport, 51 miles. I had also kept copies of Caleb's 2 school transfer notifications. Both relocations had happened without prior court notification. Both happened within 36 months of each other. I didn't move for a while. A hum of the copy machine at the end of the row started up by itself and then stopped. I found a working copy machine near the clerk's desk on the main floor. I copied the 1998 ruling. I copied the appeal. I copied the full text of section 9.114. The machine cost 15 cents per page. I spent $1.65. I walked back to the parking structure. I sat in my car. I called my cousin Raymond, who had passed the bar in 2009 and now did estate work, but still knew family court. He picked up on the third ring. "I have a question," I said. I told him what I had found. There was a pause. "Where did you find that case?" he said. "Courthouse basement." "The judge in your hearing never cited that?" "No." Another pause. "That statute is still active," Raymond said. "It's never been challenged." "I know. Thomas, if those relocations happened the way you're describing," "They did. Then you have a material change of circumstances argument that was never addressed in your interim order." "I know," I said. "I drove home. I got home at 12:14 p.m. Caleb was at daycare. Nina was at work. I sat at the kitchen table alone. I put the copies in the red accordion folder. I labeled a new tab with a strip of tape, 9.14, had Mercer, 1998, binding. I made myself a sandwich. I ate it at the kitchen table looking at the folder. Nina came home at 5:15. She saw my face. She put her bag down. "You found it," she said. "Part of it," I said. "What does it mean?" "It means we're not done," I said. "But we're not losing either." She made coffee. She sat across from me. I folded the section 9.114 copy and placed it in the inside pocket of my coat. The same pocket where I kept the interim order. 2 documents now. It would take time. But time was something I had. What this man was sitting on would take years to use, and the reason he waited is the part that changes everything. Keep watching. Year 1 passed the way years do when you are waiting for something. Work. Caleb's daycare. Dinner. The kitchen table. Caleb turned 5 in November 2017. He started kindergarten. He lost his first tooth in January 2018. I photographed it with my phone and kept the photo in a subfolder labeled Caleb, year by year. Fletcher called my lawyer in April 2018. His message, relayed to me by David Chen. My client would like to discuss improved visitation terms. Alternating weekends plus 1 weeknight. She believes this is a fair and generous offer. I said no. David relayed the message. Fletcher called back in May with a revised offer. 2 weekends per month, 1 guaranteed holiday per year, and a phone call provision. I said no. "Thomas," David said, "these are better terms than you have now." "I know," I said. "Then help me understand what you're looking for." "I'll tell you when it's time," I said. David was quiet for a moment. He was a good lawyer. He knew when a client knew something. He didn't push. Year 2. Caleb started first grade. He lost 3 more teeth. He learned to ride his bike in the parking lot of the elementary school on a Saturday morning in October. I ran alongside him for 40 minutes. He fell twice. He got up both times. He didn't cry. I thought, that's my son. Year 3. Caleb was 7. He started reading chapter books on his own. He carried them everywhere. In November 2019, I got a different kind of call. Not from a lawyer, from Danielle's phone number. I answered. "I'd like to meet," she said. "Just to talk." We met at a diner on Elm Street on a Tuesday afternoon. She looked tired. She had a lawyer's prepared list in front of her, I could tell, but she wasn't reading from it. "I want to settle this," she said. "Tell me what you want." I had a coffee. I hadn't touched it. "I want what I've always wanted," I said. "What does that mean?" "Joint custody," I said. "Primary physical with me. Decision-making authority." She shook her head. That's what I want," I said. "Thomas, I'm trying to work with you here." "I know," I said. She pushed harder. She offered money. She offered a structured arrangement. She offered a permanent holiday schedule. I said no to each one, not angrily. I said it the way you'd decline a second helping of something you don't need. She left before her coffee was finished. I sat there for another 20 minutes. I pulled the red accordion folder from my bag. I opened it to the 914 Plash tab. I read the statute again. I already knew every word, but I read it again anyway. Year 4. Caleb turned 8. He won second place in a school science fair. He was disappointed it wasn't first. I told him, second place just means you know exactly what to fix. He thought about that. He nodded like it made sense to him. Year 5. Fletcher called David in a different tone. Not the gold pen confidence of 2017. Something tighter. "What does your client want?" Fletcher asked. "What will it take?" David relayed the message to me. I was at my kitchen table. The red folder was in front of me. "Tell him what I've always said," I told David. David relayed it back. Fletcher's response: my client will consider expanded joint custody terms with a formal parenting plan. I said no. Fletcher escalated. He offered a monthly support stipend. He offered to cover Caleb's school costs through high school. He offered a structured visitation expansion that gave me 65% of parenting time. I said no to each one. Caleb asked me that fall why I never seemed angry. We were driving home from his soccer practice. He was 10 years old. He asked it the way kids ask things, without preamble, out of nowhere. Because I know what I know, I said. He looked out the window. Is it going to be okay? He said. Yes, I said. He nodded. He trusted me. That was the heaviest thing in the car. In December 2022, Fletcher contacted David one more time. My client is prepared to discuss any terms, he said. Any reasonable terms, ask him what he wants. David called me. I was at the kitchen table. Nina was making dinner. I could hear the sound of it behind me. They want to negotiate, David said. Tell them yes, I said. Now we can talk. David paused. Thomas, what have you been holding? You'll see, I said. The negotiation they didn't see coming was already 7 years in the making. This next part is the whole reason I waited. Do not stop watching. The mediation room on the 4th floor of the Bridgewater Family Courthouse was smaller than Courtroom 14. A rectangular table, 6 chairs. A window that looked out at a parking structure. Cold, the way rooms are cold when no one has been warm in them for a while. It was a Wednesday morning in March 2024. Caleb was 11 years old. I had been fighting for 7 years. I sat on one side of the table with David Chen. Across from us was Jonathan Fletcher. He looked older. He should have. He had spent 7 years being certain he'd already won. That takes something out of a person. His gold pen was still there. He wasn't clicking it. A family court mediator named Sandra Howell sat at the head of the table. She had the file in front of her. She said, "Let's begin." David stood. I had my red accordion folder in front of me. I had carried it for 7 years. It had been relabeled 3 times as I added sections. "Ms. Howell," David said, "we'd like to begin with a statutory matter that was never addressed in the original interim custody order issued by Judge Fairchild in February 2017. Fletcher looked up. Something shifted in his expression. Not alarm yet, just a narrowing. The original order was based in part on a determination that no material change in circumstances had been presented. David continued. However, we have documentation that the custodial parent relocated the minor child on 2 separate occasions within a 36-month period, both times more than 40 miles from the established school district, and both times without prior court notification. I opened the accordion folder. I placed 3 documents on the table. First, Caleb's school transfer record from the Fairfield relocation. Distance from original school district, 43 miles. Date, April 2015. Second, Caleb's school transfer record from the Bridgeport relocation. Distance, 51 miles. Date, November 2016. Third, the full text of Section 9.14c of the State Domestic Relations Code with the 1998 Mercer County case attached. Case number 1998-FC-0441, which established binding appellate precedent for its application. Under Section 9.14/, David said, both relocations trigger a statutory presumption of material change in circumstances sufficient to warrant full custody review. This statute was in effect at the time of the original 2017 order. It was never cited. The original petition for primary custody should have been heard on its merits. Sandra Howell read the documents. She read slowly. She was thorough. Fletcher leaned toward his associate and said something I couldn't hear. His associate wrote something on a notepad. Fletcher read the statute language himself. He read the Mercer case number. He read it again. The gold pen was still on the table. He hadn't picked it up. Sandra Howell looked at Fletcher. "Counsel," she said, "can you speak to the relocation notifications?" Fletcher cleared his throat. The relocations were disclosed to Mr. Osei in a timely court notification, I said quietly. David nodded. The statute specifies prior court notification, David said, not notification to the other parent. Mr. Osei has documentation that no motion was filed in either case prior to relocation. I placed a 4th document on the table. The court docket for Bridgewater Family Court, Case number 2017-FC-0112. No relocation motions filed. No notifications entered. No prior court approval requested or granted. The room was quiet. Sandra Howell wrote something on her notepad. Fletcher conferred quietly with his associate for 45 seconds. When he turned back, the gold pen was still on the table. "Ms. Howell," he said, "my client acknowledges the procedural question and is prepared to discuss modified custody arrangements in good faith." Sandra Howell looked at me. I said nothing. I waited. "Mr. Osei," she said, "what terms are you seeking?" David answered, "Primary physical custody with me, 70%. Structured visitation for Caleb's mother, 30%. Alternating weekends, 2 weeks in summer. Equal decision-making authority on educational and medical matters. Child support adjusted to current income calculation, $800 per month to me. No further relocation without 60 days notice and court approval." Fletcher's associate was writing quickly. Fletcher was not. Fletcher was looking at the 3 school transfer records and the statute text and the case number from 1998. He was looking at them the way a person looks at something they should have seen years ago. Sandra Howell said, "These terms are grounded in statute and supported by binding precedent. The documentation appears to establish a clear basis for custody review." She looked at Fletcher. "Does opposing party wish to contest the statutory application?" Fletcher was quiet for a long moment. He picked up the gold pen. He set it down without clicking it. "No," he said. The mediation took 2 hours and 14 minutes. The terms were agreed. The order was drafted. Sandra Howell reviewed it line by line. I read it carefully when it came to me. My name, Caleb's name. Primary physical custody, Thomas Osei, 70%. Decision-making authority, joint, with tiebreaker to primary custodial parent. Support, $800 per month. Visitation, structured, 2 weekends, 2 weeks summer. Relocation restriction, 60 days written notice, prior court approval required. I signed at the bottom. The pen felt ordinary. 7 years of folders and legal pads and courthouse basements and Saturday mornings and kitchen table nights, and it came down to a pen that felt like any other pen. David shook my hand. "You were right," he said. "The whole time." "I know," I said. We walked out. The parking structure was visible through the lobby window. The sun was out. I picked Caleb up from school at 3:40. He climbed into the car. He buckled his seatbelt. He asked how my day was. I pulled out of the parking lot. "Good," I said. "Good how?" I looked at him in the mirror. He was 11 years old. He had his mother's eyes and my chin, and a book in his backpack and a soccer practice on Thursday. "You're staying with me," I said. "Permanently." "It's decided." He was quiet. He looked out the window. "I always thought you'd figure it out," he said. We drove home. Nina was at the kitchen table when we got back. I put the accordion folder on the shelf in the hallway, not in my coat pocket, not on the kitchen table, on the shelf, where it would stay. She asked me with her eyes. "We won," I said. She put her hand over mine. Neither of us said anything else. Some men fight by being louder than the room. I fought by being more patient than 7 years. The folder is on the shelf now. My son is in the next room. The table is empty. That is what winning looks like for a father who always knew. The truth doesn't need you to shout it. It only needs you to carry it long enough for the room to go quiet.